morning. Looks like we've got pretty much everyone assembled. I'm Bill Carney from Emory, and I want to welcome you as well as Tina did to our program. Hope you're enjoying it. And my job today is just to serve as moderator for two people who have sort of different views, or have held different views of what lawyers do and what we ought to be training them for. Ron Gilson wrote what I think we would have to call the seminal article in this area way back in 1984. And people have been reacting to it ever since. Notwithstanding the fact that we're casebook competitors, I cite his article in my mergers casebook. Ron graduated from Washington University, got his JD from Yale, and practiced in San Francisco as an M&A lawyer before he went to Stanford. And not only has he gone to Stanford, he's gone to Columbia. He holds chairs both places, so he leads a more peripatetic life than I could possibly stand, but he's younger and stronger. I think I'll introduce George Dent now, and then we won't have to go through that. And I realized after I did this that you all have these, the program stole from the same place I did for these intros, which is from their web pages. And I guess I should also say, not so much for these guys, but for my picture. I was in a panel once, and the guy said, I'm not going to spend any time introducing the speakers. You can all look up their 10-year-old photos in the program. These guys have much more recent photos, and they still look youthful and handsome. George Dent has taught law at NYU, Cardozo, and New York Law School before he joined Case Western in 1990. He clerked for Judge Paul Hayes in the Second Circuit, practiced corporate law with Debevoise, and he is the faculty supervisor for the Business Organizations Concentration and associate director of the Law School's Center for Business Law and Regulation. I thought the way we would start this is to give each of the speakers 5 to 10 minutes to talk about the thesis of their original articles, and then to the extent that they want to react to each other at that time, let them have a go at it, and then follow with some questions, first from me and then from you. So Ron, I think you go first. You have pride of place because you've got the oldest and most seminal article.
That's a funny kind of pride. But I'll take it. I'm going to stand up and talk because it's easier to see my notes. I'm extremely grateful for Bill's kind invitation to come and speak at the meeting, especially in front of so many people. When I started worrying in the early 1980s about training business lawyers, the real truth is we could have had this meeting in a closet, and there would have been room. So simply the size of the audience is a testimony to everything that everyone in the room has accomplished. I'm also just flatly honored to share a panel with Bill and George. Over time, you develop personal habits of dealing with information overload, the rush of stuff that SSRN puts across our computer screens every morning, and you build up, you just have little rules of thumb. Well, one easy one that I use, which I recommend to you, is if an article by either of these gentlemen appears, just read it. It's an easy screen that saves time. Let me talk for a minute about where the value creation article came from, because a little bit of the history helps me to try to frame the areas where I agree with George and the one area where we may or may not agree. The paper was largely my dissertation from practice. After law school and clerking, I went to work for a sort of small San Francisco boutique. Their way of training people was to hand them a deal. I did my first acquisition 6 weeks after I showed up at the firm. 7 years later, I thought I was doing it reasonably well, and I left practice for teaching because I wanted to figure out what it was, analytically, what it was I thought I was actually doing. So the 7 years teaching was the coursework. The paper we're talking about now was the dissertation. I also think it's no coincidence that if you look at our three backgrounds in the little blurbs, there's a fair amount of overlap in the pattern. I can state the thesis of the value creation piece in a sentence or so. business lawyers have to be able to create value. If the transaction isn't worth more as a result of our participation, we're going to lose the work, and we're not going to have very much fun. As an anecdotal piece of evidence, take the role of lawyers in residential real estate in California. They have none. Title companies and real estate agents have completely displaced business lawyers in that practice. They did it because we did not offer value in that setting. So the way I thought I could set up the conversation was to identify a couple of things I've learned over the last 25 years, and that I think can set up the places where I entirely agree with George's lovely article, and at least frame one place where maybe we disagree. So, first point, there is buried in that article. If I had a prize, I'd give it to somebody who could find it, because I had trouble finding it again. An issue that I think of now is simultaneity. That is, clients really care a lot about creating value, but they also care a lot about how that value is divided. The problem is that the creating it, the win-win stuff, and the dividing it, the distributive bargaining part, takes place at exactly the same time. Everybody who's talking about putting it all together is anticipating how it's going to get cut up, and I want more than you do. The difficulty with it taking place at the same time is a lot of the techniques we use to create it, open and honest sharing of what our needs are, what things we value, collaboration, can profoundly reduce your ability to engage in distributive bargaining. That part and the importance of the negotiation structure that reflects is underemphasized in the piece, and in my judgment continues to be underestimated. That is, in transaction planning, nobody does a very good job, whether the law school types or the business school types, in talking about how you engineer a transactional structure which generates some acoustic separation between creating value on the one hand and dividing it, as an example of something that works, but I think it's the practitioners who figured it out. A standard joint venture between a large pharma and a small biotech, a collaborative governance structure and a set of nested options, does it reasonably well. But it's a very difficult problem, and it was not addressed sufficiently, and it's captured a lot of attention for me. Second point. When I wrote Value Creation, so 1984, let me set it in sort of a three-sentence intellectual history. This was still in the very beginnings of financial economics turning into serious microeconomics, and most of what I think of now as managerial economics barely existed. George, in his piece, correctly points out that the economic theory of agency, which is not figured prominently in my piece, is central to understanding what business lawyers, the problems that business lawyers are addressing. Well, point out, Bill Meckling and Mike Jensen's piece that basically introduced the subject was written in the late 70s in a journal, the Journal of Financial Economics, which Jensen had started just a couple of years before. At the same time, Ollie Williamson was just starting, right, to turn Ronald Coase's line drawing into transaction cost economics, which would give us a handle on how organizations and transactions were shaped. What's happened in the meantime has been just an explosion in the range of organizational forms that we all deal with, and a range in the positive theory that helps us think about how to do it. So the methodology that's reflected in the value creation piece, the focus on the capital asset pricing model, is a creature of its time. And the set of tools that we use, and the tools that George describes, he's absolutely right. Our toolkit has gotten much, much richer. Last point. I'm of two minds about the role of cognitive and social psychology literature that, translated by non-psychologists, have become behavioral economics and behavioral finance. Two minds because in 1985, in the first edition of my acquisitions book, I think I had the first time a lengthy excerpt from work by Amos Tversky and Daniel Kahneman appeared in a law school casebook, because the promise of being able to talk about the non-analytic part of people's behavior and bring it to bear on business practice was compelling. By and large, I think the promise remains relatively empty. We don't have techniques for identifying which biases are operative in which state. And more importantly, there's no rule that says only one bias can be operating at the same time. We need something like an arbitrage pricing model for biases that we don't have, and frankly, I don't think we'll ever have. And to that extent, in our line of work, my guess is the material is going to be less helpful. So let me move to the one point where there may be a difference, and it kind of relates to how we train lawyers, and that is the role of theory in teaching how engineering or architecture creates value. So here's the starting point, the starting point is that law as a discipline simply does not have a methodology that addresses the relationship between structure and value. Gets underscored by the fact that you'll recall the Nobel Prize in Economics last year was given to Ollie Williamson and Eleanor Ostrom for just that point. The absence of a methodology that explains the sources of value may explain why in the end Steve Schwartz seems to think that we end up being regulatory technicians. The point of that is we have to go someplace else in the university to get the underlying theory that identifies how we can begin to think about value being created. Without the underlying theory, what I end up teaching is just anecdote. There is little economic rigor, there is little analytic rigor to it, and the students have no way to test in their own minds the cohesiveness or the coherence of what I'm teaching. Put it differently, what distinguishes a professional school from, on the one hand, a graduate department and on the other, a trade school, is the obligation to take cutting-edge theory that's being done largely elsewhere in the university and bring it to bear on the real world that our students and our alumni are practicing in. It's mirror, at one level it's mirror arbitrage, but on the other hand, when that theory comes out of the law school, tied to things that happen in the real world, the theory is better for it as well. So I agree with George that the structures that we now create and the techniques that we now use are dramatically broader than we were addressing in 1984. Where I will dig my heels in, and here I'm not sure George disagrees, but we'll find out, is what in the end the task is. And the task in the end is helping our clients create value. Thank you. Lost too many watches this way.
Good thing you took it. It looks better than mine. First, just a little point of taxonomy, which might seem too trivial to mention, except I think the problems of taxonomy are very common here. I noticed that the subject of this session is what do transactional lawyers really do? My article and Ron's were about what business lawyers do. And of course there is some difference. A lot of what business lawyers do does not involve transactions. But here again is the taxonomy problem. A lot of lawyers do a lot of work that is involved in transactions and also do a lot of work that is not involved in transactions. And then you get the question of, well, what is business law? And there are an awful lot of areas that are closely related. So one of the big problems here is even to decide what it is we're talking about before we can describe and understand it. My remarks will probably be quite brief because, as Ron suggested, we agree on most things, and I'll come to his last point. I'm not sure if there is a disagreement there either. As he pointed out, I thought that Ron's article captured a lot of truth, and of course, as he said, it was written before anyone else had even addressed this issue, so it was quite remarkable. I didn't think he had captured the whole truth, and furthermore, that the profession had changed and was continuing to change with the emergence of venture capital, leveraged buyouts, new forms of entity, the limited liability company, the virtual corporation, and in a more general way, the difference between distinct transactions, one-shot transactions on one hand, and on the other hand, parties who engage in repeated transactions or relational contracts, like a joint venture. And then the next task was to describe the wide variety of tasks that business lawyers perform. And again, it's a long list. Although the transaction cost engineering is an important part of it, there were a number of other tasks involved: gathering and verifying material information, negotiating and drafting agreements. And each of these categories comprises innumerable specific tasks that vary according to the nature of the matter. And then coming closer to what we deal with with our students is describing the skills needed for these tasks. One is helping to decide if a deal should be done at all. If so, the lawyers help to choose the entity, the scope of the enterprise, the division of control, profits, and risks, the list of issues that Tina Stark has given us that we always have to run through, provisions for resolving disputes, provisions for parties to exit or to terminate the undertaking. Ron mentioned, yes, the problem of identifying agency costs, opportunism. Another thing is the skill of not only, we often mention negotiating matters, but tend not to talk as much as perhaps we should about discussing these matters with our own clients. In litigation, it's usually pretty easy to know what the client wants. If he's the plaintiff, he wants more. When you're talking with a business client, what exactly are the important issues? How important is it that certain representations and warranties be true? And how important is it that there be a veto or a complete control on one party or another? Another thing, and this was mentioned in a couple of the sessions yesterday, is that all this has to be done with attention to costs, with clients becoming more and more cost conscious. We need to discuss with students how to be cost effective, how to determine when it's really worth it to do an additional, to take an additional step. And then getting to the metaphors, Ron used the metaphor of the transaction cost engineer, and I thought a more accurate title is enterprise architect. To this label, my colleague David Porter, a former corporate partner at Jones Day, suggested adding back in enterprise engineer, because lawyers also implement designs, their own or others, to actually build the entity's ramparts and the castle walls, as well as its plumbing. And then turning to the pedagogical implications for business lawyering, a general observation, and this, based on what I heard in the sessions yesterday, will hardly come as a surprise to you in this room, is how remarkably different the activities of a business lawyer are from those of a litigator, and how little attention is paid to business lawyering as opposed to litigation in the law school curriculum generally, and in the first year of study in particular. So that, now I teach the basic business associations course as well as a couple of advanced courses. And a constant problem in the basic business associations course is that students by habit think in terms of litigation, not in terms of planning and contracting. They aren't accustomed to thinking about what may go wrong down the road, including how someone may behave opportunistically in a business relationship. And they're not used to thinking about how to prevent or resolve future problems. They're also not used to thinking about negotiating outside of litigation. Unlike litigation, in transactional negotiations, the other party can just walk away. And even if the other party does not walk away, in many cases, again, when the parties are looking to a relational contract, a joint venture, a venture capital investment, the parties are looking to continued relations down the road, and even if the behavior of the lawyer is not so atrocious as to destroy the deal, it may be bad enough to sour relations between the parties. There was some mention yesterday, and this is consistent with things I've heard, that very often business people view lawyers not as deal makers, but as deal breakers, people who stir up trouble between when the parties were all getting along just fine, the lawyers come in and start to stir up trouble. Now, that may be an unjust accusation against business lawyers. It is also claimed by many business lawyers that in some cases the parties have agreed at a level of glittering generalities, and they're getting along just fine because they haven't paid any attention to the tough issues. And then when the lawyers come along and point out there are some tough issues, the parties start to have a falling out and then blame it on the lawyer. So I think, but it is nonetheless true, I think, that the kinds of attitudes one brings into litigation are often inappropriate for business context, and part of the job of the lawyer is not to destroy, but rather to foster the friendly relationship between the parties. Now, that kind of brings me to Ron's last point, and I think it's an interesting question, and I don't know. I don't know to what extent I agree or disagree with him. In part because I'm not sure exactly what he's saying, and in part because I'm not sure exactly what I think about it myself. But when we talk about a theory of the relationship between structure and value, first of all, I don't know how much there is available in other fields about that, how much theory there is out there outside the realm of the law to draw on. I know that there is a fair amount, for example, in the choice of a form of strategic alliances. But that's just one part of what business lawyers do. I'm not sure how much theory there is out there to draw on. Perhaps a more basic problem I have is that I think that application of theory here may be extremely difficult because of the infinite variety that matters take. To have a theory of, well, in this situation you do A, and in that situation you do B, works fine if you've got just two choices in two basic situations. I think a lot of business lawyers would tell you that every deal varies a little bit from every other deal, and that you have to adjust to those specifics. And given that, now, I mean, at some level, of course, there is a theory. You wouldn't try to organize Microsoft as a general partnership. But that's obvious. And then when you get to the area where lawyers are needed, we don't need an expert to tell us that Microsoft should not be operated as a general partnership. When you get to the situations that people really do deal with, I wonder if that isn't the point at which you basically have said, well, theory no longer works. Now we have to deal with the individual situation. So again, I wonder how valuable theory could be. But all right, I know Bill has a number of questions he wants to discuss with us, so I will stop with that.
Just for reference, put up a slide with some of the leading, at least my view of some of the leading articles, in addition to Ron's and George's, that have contributed, I think, in meaningful ways to the debate. And one of them is Steve Schwartz's article, where he speaks generally of the lawyer as somebody who reduces regulatory costs in a transaction. And in that light, Ron wrote his piece in 1984, and the Delaware courts were about to roll up their sleeves and really dig into corporate law, particularly mergers and acquisitions law and the duties of directors, and look rather carefully at the contract provisions, all with a very suspicious eye, I think. And at the end of the day, it's been my observation that not just in M&A deals involving Delaware corporations, but involving all corporations, Delaware law has had an enormous impact on what the acquisition agreements look like, and the sort of background law that we all think we have to deal with, even in states where there isn't much law, on the theory that the worst case would probably be Delaware. Ron, would you think that what's happened in Delaware since you wrote provides a larger role for the lawyer as regulatory cost saver?
It certainly plays it makes the landscape more complicated in no small measure because of the fact that Delaware, in my view, has two laws. It has law that the Delaware Supreme Court occasionally utters, typically in tongues, and then it has the a deal lawyer's working law that is a continual dialogue with the Chancery Court that's grounded in facts in an important way, so that teaching doctrine, because of that, has become both dramatically more interesting and more complicated. But what's interesting about where Delaware law has gone, it has pushed on, in my view, it has pushed lawyers to be creative about structure. Because in the end, the worst thing that could happen to a vice chancellor is that they actually have to make a decision about value. And if they can just push the lawyers into designing a structure which they're sufficiently confident about to give credence to, then the court gets out of having to value things, and it pushes us back where all three of us and everyone I think in the room think is important, which is the lawyer's ability to be architect, engineer, in devising a structure that works. In the particular case of Delaware, the audience is somewhat different. It's not just your client and the other side, but persuading a bunch of sophisticated Chancery Court judges that what you've done is sufficiently, the structure you've created is sufficiently reliable that they don't have to do it.
George, your article, and it seems to me that you and Ron are much closer together than the two articles suggest separately, suggested that the broader role for the lawyer of advisor and counselor and planner, absent transactions, and I think that's a very valuable addition to the literature. But it seems to me we see a spectrum of activities for the lawyer, from counselor where there's no action or activity taking place in particular, all the way to the more dramatic example of the one-shot deal, and the acquisition agreement as being that. Does that make it difficult or perhaps impossible to sort of have a general model of what it is lawyers do? I'll add one more piece to that, and that's the lawyer as foil. One of my last roles as a lawyer, I had a favorite client. He was a free-spirited entrepreneur, and sometimes we would go to negotiations. It would be my job to take the hard line on the opening, do the opening argument. And as soon as I had done that, Ed would back off and say to the other side, no, wait a minute, Bill's being a little unreasonable here, and would offer something a little more generous, and the other side would often leap to take it because the appearance was that he was giving up a lot more than he really was. And I realized that I had become a violin that he played in whatever way he chose to play me, which I didn't mind being a violin. I might have even been a Stradivarius, probably not, but it was a fun role to play. George, do you think, can we generalize in any meaningful way about how lawyers add value?
Well, your first question, does it make it difficult or impossible? That's easy. Yes, it does. Can we generalize? I think, well, we certainly need to. How do we decide what it is our students need to learn? There's no point in teaching them some narrow set of skills that for a very narrow area of practice that they probably will not enter, and even if they do, will probably change over time so that what they have learned will not be of much use to them. So we do have to generalize, but just how we go about it is I think, a very difficult question. Can we describe a set of general skills? One reason I mentioned something that doesn't come up often in the literature is talking to clients, because that certainly is something that cuts across all the practice of business lawyers. And again, it's something that just doesn't come up much in litigation. You don't have to ask your client in a products liability case, well, what would you like, more money or less? But in business transactions, it's very common. And I think just to take one small example, I think that certainly students and probably, I don't know how quickly lawyers overcome this after they graduate, but I think there's a reluctance to ask business people questions. It would help me to understand how your business operates and what it is you're trying to do in order to help to design the entity, and in order to help to negotiate a deal that will work for you, because you're afraid of sounding stupid when you start asking, would you explain your business to me? And yet, when you do talk to people who really practice in the area, that's one thing that's absolutely essential. In business, clients often complain, right at the top of the list of complaints is that lawyers don't understand our business. So that would be one small example, how to talk to clients and the importance of understanding the business. But then going beyond that and coming up with a general, a list of general skills that would really be useful long term, I think is a very difficult project.
I think I'd like to shift very briefly to my last topic, which is to shift us over towards the future of business education. I get the next slide up there. I want to talk about some models of business education that we now have in law schools, and not surprisingly, I begin with Emory's, which I could also describe as Tina Stark's, to give credit where credit is due. We have a fairly elaborate certificate program, which has a schedule of required courses, which takes up almost a year of somebody's time after their first year. And they run from the basics, rudimentary accounting knowledge, which that course can be waived if they have sufficient experience elsewhere, through the basic corporate course and contract drafting, which is something that most of our students who are in the program will take in their first semester of their second year, because it's a prerequisite to deal skills, and the other courses along the way, followed at the end by a capstone course, which is either a workshop, a simulation, or we have a series of field placements with corporate clients, largely with corporate clients, a couple of government agencies that fulfill that requirement. So they get a progression of experiences, and it's pretty rigid. It's not so rigid that we haven't had a large demand for it. This past year, the rising 2Ls, I think Tina has a requirement they all have to have an interview with her and figure out what it is they really want. And I think she had 110, which is 50% of the rising 2Ls, sign up for the interviews. And I think you said about 75 students who were admitted to the certificate program. So, it's a significant number. It seems to be playing well in the marketplace. The next thing is we have, a series of elective courses. Many of those are taught by adjuncts, but it's a pretty rich array for those who want to add to that set. But we have consumed almost 1 year of their program if they go that route. The elective courses continue with, and workshops are the capstone classes, and the field placements are with corporations and with the SEC and the IRS, not the IRS, and Federal Reserve Bank. So that's the group that we have. It's a fairly structured program, requires a commitment to a lot of hours. Case Western's program is a bit different. 2 courses, I think it's 8 hours of required courses, and then an additional 7 credits, so that makes about 15 hours, which is considerably less and considerably more flexible for the students, to Stanford's, which represents kind of the ultimate flexibility, which is just a grouping, I think, as best I can tell in the catalog, and I assume some advising along the way that about what students might want to take. In contrast, the other end of the spectrum is the Northwestern model of a 3-year JD MBA program with a full year spent in the business school. The number of credit hours required in the law school is 72 hours. I think ours is 90 here. And the others are in the business school, and that's somewhat reduced too, I'm sure, for the MBA over there. So those are the models that I'm aware of, the breadth of models, and I'd like if either of you gentlemen have any comments on the success or your desires for the future in your own schools or what we ought to be doing, I'd appreciate it.
First, it's a great question. Actually, let me back up and even broaden the question, if I may, Bill. Note that in most countries, including most industrialized countries, law is an undergraduate program, and so some people might well ask, why do we even need law schools? Why don't we just get rid of them altogether and stick it all in the undergraduate program? And of course, the other side of that coin is that following the undergraduate law program, students serve what is basically a lengthy apprenticeship. So I think that's what is the best way to get get young people who want to be business lawyers to become business lawyers. A relatively brief period of general education followed by a long apprenticeship, or a very detailed program of study carefully prescribed that will turn them out ready to hit the ground running. It's a good general question. Of course, we are hardly disinterested. We want more legal education. When people start talking about a 3-year JD MBA, in which students would spend only 2 years in the law school and 1 year in a business school, of course, deans immediately start to say, wait a second, what's that going to do to our income? Those are good questions. I guess, and plus there's the question of what students want and what they reasonably want. On one hand, they want to come out of law school able to get a job. On the other hand, they don't like to be too restricted, especially early in their law school careers. That's that's not an answer. That's just more questions, I realize, but I guess that's probably the best I can offer.
I started out thinking the MBA, coupling an MBA degree was a great idea. I think one other thing I've learned over a lot of years is that the notion that you can get somebody else to paint your fence is just that, it's fiction. The MBA program doesn't bring the set of theory or set of skills that are not traditionally law that I think a good business lawyer does. Let me frame the issue in a setting. I want to teach the students how to choose an exit option for a closed corporation. And I can do the arbitration bit. One person gets an arbitrator, the other person gets an arbitrator. The arbitrator picks the value, and the range of those. And on the other side, I can just plug in something that's really cheap, as the others isn't, and say, well, one person makes an offer, the other person gets to buy or sell. And that's quick. When are they appropriate? There's a bunch of game theory that talks about pie splitting. That is, and Bob Minuk and I, in a fit of doing something neither of us are good at, wrote a case about this. I want the kids to walk away with some rules that grow out of theory that help them identify the circumstances in which when one of those techniques is likely to be preferable to the other. They won't get that in an MBA. They may get some game theory, but it won't be applied. It won't be put in the context that I want them to have, and that turns out to run pretty much through the curriculum. So in the end, I end up in a position where I think the theory becomes a critical way to give students the ability to select among options. But in the end, I don't find any place else in the university that's likely to apply that theory in a way that we want to train them. So in the end, a very high-end professional school is doing something that nobody else in the university can do, and unfortunately, I can't palm it off on the business school or the economics department or the psychology department to do the integrative work of taking theory and making it applicable to what our students are going to do in the real world. Nobody's going to do that hard work for us.
We are pretty much out of time if we're going to stay on schedule. I see Tina nodding, so yes, boss. We will close with this and invite anybody who has questions. I'm sorry we ran out of time for questions. One of the authors of one of the articles that I listed, Jeff Lipshaw, is just sitting here with his hand ready to go up. And 5 minutes, okay. I'll cut the coffee break short by 5 minutes.
Now, that was a beautiful negotiation. Exactly.
Jeff, do you have a question? I saw your hand, I saw you writing notes.
Yeah, because I do. So much is in the metaphor. Bottom line of my question, Ron, to you. Talk about the metaphors. My metaphor is I take it that what you're looking how do we deal with what I see as your not going to be able to find what gives us
So, my idea of the theory, of the role that theory plays, I teach it sometimes, it's a little out of date now, by the little routine that used to be done at the beginning of Sesame Street, where there was a picture, there was a board with a picture of 9 things, and the little song was, one of these things is not like the other. There are students in the class who, every year, who have sense. At 12, when they were 12 years old, they understood intuitively which box to put things in. For me, the role of what I'm deriving from theory, from economics, from psychology, is in effect a set of shorthand algorithms that will let the very smart kids in the class, but just who don't have that weren't born with that particular intuition, perform the same sorts of roles and very effectively. So where am I going to look? I'm going to take pieces of it from everywhere. So, for example, it is not, in my mind, a surprise that the best policy work done with cognitive psychology and biases largely was the work of a lawyer. The notion that I can switch default rules, and an economist too, but that I can switch default rules and I can help with individual decision-making in that fashion. That's getting done. It's the idea of taking a tool, taking an idea that was developed elsewhere, but then brought to bear on the complex problems that we address in a law school in a very powerful way. I don't think that extends into transaction setting, but it doesn't mean it's short there. What doesn't happen in the other disciplines, and what makes law, frankly, so much more fun to be an academic in, is that our world doesn't fall in little disciplinary boxes. We deal with real people doing real things, and lots of them are rational, and lots of them have a little bit of irrationality, and sometimes we're trying to put rationality on what is often an emotional problem, busting up a 2-family close corporation. The only place in the university where academics truly get rewarded for doing interdisciplinary work is inside a law school. And that's largely because we don't have much of a discipline ourselves, so nobody cares that we're grabbing stuff. So again, I think it has to be done in-house, because we're confronting each of those disciplines with the discipline's own worst enemy by complicating the problem that it's trying to solve, and they won't do that. So we get to do it. Now, it's fun because it lets you be a dilettante. It lets you decide what you're going to learn this year. But my experience over the years is the students walk away with a set of analytic tools that let them confront the sets of changes that George described so wonderfully in his article pretty seamlessly.
And with that, I think I'll repeat myself. Well, we have run out of time, and if you have any questions, come on up.